Hi, this is Jim Cunningham, and a lot of people ask, what do you do with real estate when somebody dies? So, what are we talking about here? Well, what happens when a person dies who owns real estate? Now, that may seem like a pretty simple question, but I will tell you as a lawyer in preparing this very, very potentially complex question, it is not always apparent who ends up with the property and what you need to do. A lot of these rules, frankly, are not written anywhere. And that's why you go to the lawyer and the lawyer looks at a situation to say, you need to do these things or not do these things, right? So, what if the property's not in a trust? What if it's in a partnership? What if it's in an LLC? What if it's jointly owned with another person, right? What do you do? Where do you start? What if it's rental property? Is that treated differently than residential property? The short answer is yes, it can be treated a little bit differently. And the way that you succeed to property or way you inherit property for some assets is different than others. What if there is more than one owner? What if it's not just you or mom or dad? What if it's maybe a couple and another couple? They've gone in together on a piece of property. Who ends up owning the property? So we're going to talk about that. And what should you not do before or after somebody dies? So part of this is what to do. And then there's the what not to do. Okay. So that is something that is, in a sense, equally important. So I would say, starting with what not to do, don't do nothing for a year. So this is very common, right? We hear this. So typically somebody loses a spouse and that person comes in and they say, well, I was told not to do anything for a year. Not getting married, probably not a bad idea for a year. You might want to pump the brakes on that. Not selling your house and moving, maybe you want to wait on that. Don't wait a year to see your lawyer or your CPA or your financial advisor. You need to see those people pretty much right away. I mean, not right away, but within a very narrow period of time. And you'll see there are some time deadlines on here and reasons why you would want to reach out to your attorney, CPA, and financial advisor. Title controls. We'll talk. What does that mean? It means the name on the deed drives a lot of this, drives a lot of the law on this, and answers the question, who ends up with the property and what do you need to do? What is the process you go through to deal with someone once they passed away? We're going to talk about probate versus trusts and why you want to stay out of probate. We're going to talk about acceleration clauses in loans. So very important when somebody dies, sometimes that's a default. Sometimes there's a due on sale clause. We're going to talk about reporting to the county assessor and now the federal government if you have an entity with the Financial Crimes Enforcement Network, FinCEN, and appraisal and adjusted cost basis. We'll talk about that. And then we'll finish up with federal, estate, and state death taxes. State death taxes. So if you own that piece of property in Oregon, there's a up to 16% death tax because the real property is in Oregon, and it's 20% in Washington state. So adjacent to California, a lot of people don't know that. I'm Jim Cunningham. I'm an attorney among many attorneys in our firm now. We handle all things estate planning, trust administration, real estate, and business, estate for business owners. We have offices in Northern and Southern California, the Sacramento Bay, San Francisco Bay Area, and Los Angeles area. If you're watching this on YouTube, please subscribe to our YouTube channel. This will be on YouTube at 6 p.m. today. If you're watching it on YouTube, obviously it's already there. I'm a lawyer. I'm talking. This really should not be construed as legal advice. So this is very important. Don't watch this and go, oh yeah, Jim explained everything. I'm going to go out and do this myself, because you can get in a heap of trouble with this. And really you want to get qualified advice. So what do you do with real estate after somebody dies? Now, lawyers will say real property. Most normal humans, people who are not lawyers, will say real estate. So when I say real estate and real property, I'm meaning the same thing. The big question is, do you sell it or keep it? And I think this is one of the big, beyond the, gee, what do I need to do? The question behind the question really is, mom and dad died. Should I keep this property or sell it? That's a big decision. And a little bit of a spoiler alert, you're better off selling it within a trust or a probate process than you are as an individual. You have at least two fewer warranties of title. So a little bit more protection in the sale of the property. And, do the kids really want to deal with leaky faucets, plugged up toilets, and rent control? Many of our clients own properties that have varying degrees of rent control in them, right? So depending on where the property is located and depending on what the law is from time to time, and we're recording this just before a general election in 2024, and there is yet another ballot initiative concerning rent control on the ballot. So a lot of people, they don't want to deal with it. And then the next question is, can the people who inherit the property, can the inheritors sell the property and avoid capital gains tax? So really, again, another spoiler alert. I mean, if we're talking about you, the people you leave the property to are much better off if they inherit that, broadly speaking, after you've died. Now, that does not benefit you because you're dead. All right. So just to be clear, if you're watching this and you're thinking about your parents, I mean, this could benefit you. But it's very important to understand, we're going to talk about this adjusted cost basis at death. So in the United States, when a person dies, property that is included in a person's estate gets what is called a full adjusted cost basis. So it doesn't matter what you paid for it. Doesn't matter how much you've depreciated the property, it does reset and get a new cost basis, and that can save the family a tremendous amount of money. So when you hear this business about, oh, death taxes and all this other stuff going on, there is a huge tax benefit when somebody dies. You get that adjusted cost basis, and we'll explain what that is. What if there is a co-owner? This actually comes up more often than you might think, and if it comes up with you, you are not alone. What if there's someone else on that property other than the person who owns the property? Now, it could be a spouse, it could be a business partner, it could be a random person. It could be, somebody who's invested with you. But we're going to talk about what happens if they're co-owners, and really what is the true after-tax return on the investment. So one of the things is many people are very upset that the parent-to-child reassessment exclusion went away under Prop 19. But bear in mind, if you get a full adjusted cost basis, right, you have more depreciation. That may offset the higher taxes. Both, by the way, the depreciation gives you an income tax benefit, and the higher property taxes are also deductible. So when you look at the after-tax return, I think that's where you really need to involve your attorney, financial advisor, and CPA to figure out, the attorney typically figures out, are you getting an adjusted cost basis or not? If generally speaking, if it's in an irrevocable trust, many times you're not getting an adjusted cost basis. So that's why you need to bring in the CPA and financial advisor to figure out what's the best strategy. What about the legal issues? Who has the power to sell? Very important. Just because you're part of an LLC that's on the deed and you pass away, that doesn't mean that your estate or your family has the power to sell. That does not mean that you can sell to anyone. So we'll talk about that. So what do you do with real estate? You can keep it. Typically we see and live there. We're going to see this with personal use assets. The primary residence exclusion is under Prop 19, meaning you can leave your family home to a child and exempt a little over $1 million in reassessment. We covered that in other webinars. You can keep it, and if you're not living in it, you can rent it out, right? And you have this tax reassessment issue, or you can sell it, and then we have a capital gains tax issue. Again, broadly speaking, when a person passes away, that is eliminated, except in the case of, if mom and dad passes away and dad's portion of the property goes to a B trust or a bypass or a credit shelter trust. In that sense, sometimes you're not getting your full adjusted cost basis. There are pros and cons for keeping it. Some people have an emotional attachment. There can be tax benefits if it's a house, but then you have to look at, how are you going to split this up between the family members? You've got some maintenance issues. Do you keep it and rent it out? I think that's fundamentally a math question. That is one option. But again, if 3 kids are inheriting the property, do the 3 of those children really want to be partners on that property? And then you can sell it. And then I think you need to look at the tax analysis on whether you sell it or not. So can real estate be kept out of probate court? Again, we are talking about when somebody dies. And when somebody dies, immediately lawyers think, is this going to involve the probate court or not, right? When somebody passes away, we're not talking about when somebody becomes incapacitated, separate issue. This is specifically when a person does pass away. And something to understand on a high level is when is a probate court required in a post-mortem or after death situation? Here's what happens. When a person passes away, there has to be someone to sign a deed. If there is a structure in place for a human to sign a deed, right? So maybe you have it in a living trust. That is an example, the successor trustee, and we'll talk about this. The successor trustee can sell the property. But if mom's on the deed and mom dies, there's no one around, right? Mom's not here to sign the deed. She's dead. What do we do? Well, that's when we have to go to probate court. And in probate court, the person designated to handle the affairs of a deceased person is called, broadly speaking, a personal representative. So we're going to use this term personal representative. It also includes a successor trustee. So when we talk about notice requirements with the assessor's office, they use the term personal representative or state representative. We're going to use that term, but broadly speaking, this could include an executor, could include a trustee. It could include a person who is informally handling the estate. So it's a very broad term. If you go to probate, typically a court is going to appoint a personal representative. And remember, title controls. So there are you're either going to go through a trust administration, or you're going to go through a probate. Potentially, you could go through a corporate transaction, and we'll talk about that in the context of LLCs. So when is probate necessary? If you're watching this video, that is the Norwegian flag in the upper right-hand corner. If you do not have a fully funded living trust, meaning you have a living trust, but the person who died has a living trust, and this person's name is on real property, real estate, not the trust, you may have to go to probate court if you want to deal with this property. So what do I mean by that? Well, you might have to go through a full-blown probate. We cover this in other webinars. It's a very long process. What is a full-blown probate? That's a notice proceeding. It typically lasts 16 to 24 months. There are some shortcuts, right? And there are two cases. One is Hegstad and the other is Ukstad. These are not people from Norway. I suppose our ancestors were. These are both Norwegian names. I do not know if these people are related. And if you're not Norwegian, they may look like very different kind of names, right? So these are situations in Hegstad where the property was in the trust, but then the person refinanced the property and took the property out of the trust. Very common situation. Didn't get to putting the property back in the trust. You can go to a court typically and have a single hearing and pull that property back into the estate. Ukstad is a slightly different case where the property never went into the trust, but that property is listed on a schedule of assets. And again, that's a single court hearing where the court puts the property effectively into the trust. So it's very important to understand, sometimes a full-blown probate is necessary, and sometimes it's not necessary if the facts and circumstances permit that. So this goes back to the question, what do you do when somebody has a living trust, the property's in the deceased person's name, and you have to go to probate court? There may be a shortcut for that is where I'm going, but you're still going to probate court. When there's only a will or no will, you're going to probate court, likely full-blown probate. Now, if the assets, and we're talking real estate specifically here, if real estate is worth less than $184,500, then you can do it by a single hearing. And if it's even lower than that, you can do it by an affidavit. Now, you may say, Jim, I don't know anything worth $184,500 that involves dirt in the state of California. I get that. That's partially true. But as you're going to see, sometimes we're talking about fractional interests in property, maybe a 10th interest or a 20th or a half or a third. And it just depends on the nature of the title. And sometimes we have fractional interests in property that aren't in the trust. So we'll cover that in a little bit. Probate court is the only way, right? This is the only way to sell, dispose of, or otherwise transfer a decedent's property to the people entitled to it if these exceptions don't apply. So if you don't have a will, or if you have a will, don't have a trust, or no will, probate is the only way typically to resolve this. This is very important. Probate is a completely public process, and it is creditor focused. So the idea is we want to avoid probate. So again, if the kids want to sell mom's house and mom's passed away and her name's on the deed, she's not around to sign the deed. Now we're doing this about a week before Halloween, and we could make a Halloween joke about mom, still being around, and maybe mom's talking in the kid's head still about even though she's no longer on this earth. But the reality is, if her name's on the deed and she's passed away, you're going to have to go to probate court to deal with the property. So again, probate court's time consuming. We cover this in other webinars. The probate fees can be 4 to 8 and sometimes 100% of the estate. If you have $1 million property with a $950,000 mortgage, that $50,000 in equity is going to go to attorney and executor fees to probate the estate, so the heirs get nothing. Again, probate is a public process. Living trusts are private. Probate is creditor focused, meaning the primary function of probate is to pay creditors. That is not the case with the living trust. That is not the primary function of a living trust. So it is the difference between a decedent's estate and the probate of a will, which is focused on paying the debts of the decedent, the person who died, versus a living trust, which is focused on getting the assets of a decedent to the beneficiaries. So That's when you might hear formal probate if if you're talking to an attorney or you're thinking about this or learning about it, and that formal probate is that 16 to 24 month process. Again, we have a probate fee calculator on our website. I encourage you to take a look at it. A $3 million estate has 86,000 in attorneys and executors fees. And we'll cover trustee fees in a little bit. So how does a living trust work? So most of our clients have a living trust. And again, what do you do with real estate when somebody passes away when it's in a living trust? Well, a trust is like a bucket with a handle. Your house, your investment property, stocks, bonds, mutual funds, are transfer your house and your investment property transfer to this bucket by deed. So if you own the property and you set up a living trust, in order to fund the trust, you have to transfer that by deed. So you sign a document, acknowledged before a notary public, then it's in the trust. That's a matter of public record. So the whole world can see that you've done this trust and you're the trustee of this living trust that you've created. IRAs, 401ks, annuities, and life insurance stay out of the trust. All trusts have a trustee, right? Someone who's holding the bucket, a beneficiary, and a corpus. A beneficiary is a person who gets it, the goods or the property, and a corpus, which is assets. So when you do a living trust while you're alive, you're the trustee, you're the beneficiary, your assets go into the living trust. When you die, when you leave this earth, everything that you have earned and created and saved stays on earth. It does not go with you. I am sorry to break this. This is bad news. We're not Vikings and we're not Egyptians trying to send stuff to the afterlife. Everything you have worked for in your lifetime stays here. Your soul leaves the planet. Whatever happens, I don't know. I haven't been there yet. And your stuff stays here. What's a beneficiary? Well, you can think of it like as a successor beneficiary. When you die, your kids, for example, might be successor beneficiaries. It might be your spouse. It might be charities. It might be whatever it is. But there's always going to be a beneficiary. So when doing estate planning, you have to think, where's this stuff going to go when you pass away? If you say, gee, I don't have anyone, you still have to figure it out, because if you don't have a plan, the state of California has a plan for you. It's called intestacy, and it essentially goes to family members. So you may not want to leave it to your family members. And if you don't want to do that, then you should make a plan. So again, trusts take care of your assets while you're alive, and they avoid probate at death and incapacity. Also, trusts can protect for the people who inherit the property. A living trust can have provisions that protect that inheritance from divorce, taxes, and lawsuits. And revocable trusts typically become irrevocable at death. And again, a living trust is private and beneficiary or heir focused. Briefly, what is trust administration? So after a person who sets up a living trust, they put real estate into this living trust. Trust administration is the process a trustee follows after the death of the grantor, which is the owner of the trust. So that's you creating a trust. You put your property in, you die, some other human is going to be at the helm, right? Driving the boat and handling the process. So you have to identify and take control of trust property, pretty obvious, manage the property, pay debts and expenses, and then distribute the assets. And this is done by the person you designate in your trust as successor trustee. So you're the current trustee, the successor trustee is the future trustee. And when you die and that successor trustee assumes the role of trustee, we drop the term successor and we just say trustee. You can avoid probate fees of 4 to 100%, as we've discussed, right? So sometimes the fees are 100%. And trust administration, I would say broadly speaking, performs a similar function to probate in terms of collecting assets, paying debts and expenses, and distributing assets, but it does so without court involvement. So you have to do stuff with the trust. It's not like you're skirting the compliance rules. It's very important. All these things that we're going to talk about needing to do, you still have to do if you have a trust administration. So I think a lot of people are under the mistaken belief that when a person passes away, there's nothing to do. I don't need a lawyer. I can just wing it. Well, you're going to see not such a good idea when you have real property, because it can end you up a little bit in hot water. And I would say trust administration fees are often on an hourly basis. The attorneys that I know that do a lot of trust administration, our firm would be one of them. Broadly speaking, most of these firms are doing it on an hourly basis. You may have some do it on a percentage basis. I frankly think that's a bit unfair. It can be unfair to the client because sometimes they're overcharged. So really the amount of time involved should correspond to the fee paid to the attorney. It's almost like a time and materials. Title. We talked about title, and I would say this is probably the heart of what we're going to be talking about here, and understanding the importance of title. Now, what title am I talking about? I'm talking about going down to the local county recorder's office. So the way The way real property records are maintained in the state of California is on a county level. California has 58 counties. Real estate, real property is located within one of these counties, right? So all the real property, it's mapped out in California. If this parcel of property appears or is located inside of one of these counties, that's the county that you would go to the recorder's office to find out, hey, who owns this property? This is kind of like the original blockchain. This is an immutable record, meaning we know who owned whatever parcel of property in 1875. We can just go back on the chain of title. So when you go on title, or when a person or a corporation or a trust goes on title, that's something that's going to be there forever. And what people look at for the ultimate reliability is what is recorded. So this is a little bit different than like those Old West movies where you might see where somebody is in a poker game and they put the deed down as a bet. It doesn't work that way. So if you say, I'm holding this deed and I own the property, really what's important is the actual title. Now, there are some exceptions to that. So if you're an attorney watching this, go, well, Jim, we learned in law school, blah, blah, blah. That is true, broadly speaking, title controls. There are different ways to hold title. Sole ownership, that just means I'm on title. Community property, spouses, registered domestic partners. Community property with right of survivorship, slightly different. We'll talk about that. Joint tenancy, tenancy in common, and then LLCs and partnerships and trusts. So what we're going to do is we're going to take these one by one and go through these, and so that you understand the importance of title. And when you do estate planning, something you need to know. When you do estate planning, if you go to a competent lawyer to help you with your estate plan, that lawyer should be pulling your deeds, meaning going to the record title to see what the last recorded deed is, or what we also call the vesting deed, meaning how did you acquire title to this property? Because that's really what matters. So when you come in and you see the lawyer doing some things like looking at deeds, you say, well, look, I have the deeds. And I don't want you to do that, lawyer. We're not doing our job. We're not doing our due diligence. We need to pull those records. It's not that expensive. Doesn't take that much time to look at a deed and title, but it's something that's part of doing I would say a competent or a proper job when it comes to estate planning. Individual or sole ownership, only one human being on title, right? One human with a heartbeat, not a dead person. One person on title, 100% ownership. They're going to own that property, meaning each parcel, or we do have meets and bounds, which starts at a pipe drilled in, or pipe pounded into some hillside in 1850 that everything's measured from, and no one can find the pipe because it's rusted. But the idea here is that all the property is divided up into parcels, and that parcel is a single parcel. So you have to go through a different process to subdivide a parcel. So what we're talking about here is one human owns that entire, right, the boundaries of that parcel. And that person has the sole right of possession. This, very fundamental to Anglo-American law. The interest may be conveyed, meaning you own the property, and in the United Kingdom and all of the English-speaking world, property rights are very, very important. And this is something that is not the case with other countries. But you, as the owner, have the sole right of possession. You can transfer it to whomever you want. There are typically no restrictions, right? The purchaser, right, if you sell that, the purchaser becomes the sole owner, so you have no retained rights to that property. At death, the interest passes by will. So if you're the sole owner and you die, that interest is going to be passed by will, and we'll have an example. And creditors. So a creditor can come in and seize the property. So if the owner of the property gets sideways with debts and a creditor sues, they can seize that property. And there's a presumption that the property is owned by the living human on title. So there is not a presumption that somebody else owns it, but in law, if you see a name on a title, the presumption, unless you have evidence to prove otherwise, is that the person on the title is the owner of the property. Now, this may seem really obvious, but this is not the same throughout the world. So it's a little bit different in other parts of the world. So let's look at an example. Oscar owns Blackacre. Oscar, by the way, Oscar is the owner. I'm also a pilot, so you're going to see, if you're a pilot, you might be noticing the names throughout this presentation. I'm using the words we use for the alphabet in aviation. Oscar owns Blackacre. Oscar dies with a simple will, no living trust. Victor, who should be, see, now I got the slide wrong. I should have picked this up. Victor is Oscar's son, is named as executor. Just bear with me on this. And so we represent Victor, the son of Oscar, in a probate action. So Victor, son of Oscar, is the executor and sole devisee, which is, just think of that as heir, the person who inherits under the will, and hires Cunningham Legal to represent Victor in probate court to probate Oscar's will. 16 months after hiring us, The probate's concluded and title to Blackacre is ordered by the probate court to be distributed by Victor as executor to Victor individually. So now Victor becomes the sole owner. And then we prepare and Victor signs before a notary public, a personal representative deed. Now, this is interesting because this is like something a lot of lawyers forget. You can record the order, but really it's best practice to actually have a deed where Victor, as executor of Oscar's estate, transfers the property to Victor individually. So that's the process. So if you're stuck and you go, gosh, I'm Victor and I have a similar situation where my parent died, what do I do? You're going to have to go to probate court. And if you're not represented, you can reach out to us and we can help you. Community property. So it's very important. Only spouses and registered domestic partners can own property. Literally the title is community property. And we'll have an example. Equal ownership and managerial interest. Community property means each spouse owns the whole. A bit of what we call legal fiction, and this is an entire course in law school, community property. And by the way, we get this from the Spanish, and I believe this comes from Arabic law originally. So this is kind of took a really circuitous route to us here, being a former part of Mexico and Spain and California. That's where we get community property. Equal ownership and managerial interest. Title is in the community, right? Not necessarily in the individuals as individuals, but essentially these individuals representing the community. Equal management and control. Any transfer, very, very important, any transfer requires the written consent of the other spouse. Now, if both spouses are in title, that's fine, right? Because they're both signing the deed, and that's the consent. But if one spouse is on title, and you may think, well, why is one spouse on title? Why not both? It is possible to take title as community property. So if I buy a piece of property, I'm married. If I buy a piece of property with community funds, that is community property. When I go to sell that property, a title company will ask for a quitclaim deed, not a quick deed, but a quitclaim deed from my spouse. So if you're involved in a real estate transaction, you go, you know what? My name's on this property. I'm married. My spouse is not involved in this. Why on earth are they involving my spouse to sign this quitclaim deed? It's because they need that consent of the spouse to transfer the spouse's interest. So that's why they might be asking for a spouse who's not even in the chain of title to sign a document. So one spouse can own, again, 100% of the property's community property. On death, really important, folks, pay attention to this. Half goes to the survivor, meaning if people are married, they're two people, right? One spouse dies. That other spouse already owns half of the property. So that spouse gets half of the property. It is an open question what happens to the deceased spouse's interest in the community property. That is what lawyers call divisible, right? Like a devise, like in a will, that can be passed by will by the deceased spouse. So when talking about spouses and passing away, we say deceased spouse and surviving spouse. The deceased spouse can leave that half of the property to whomever they want. People flip out when they hear about this, okay? When I did litigation, I was involved in a case where it was a very similar situation. There was a client who died and had title to community property, but left the community property to his son, who was not the son of his surviving spouse. So it was a stepmom. That was a big case, a very knockdown, drag out case. So it's important to understand title is really, really important because you may not, it may be that your spouse just randomly leaves the property to somebody else. And then the question becomes, is this separate or community property? So that's a whole other question of characterizing the property. So the successor is tenancy in common with the devisee, meaning if this property is owned by spouses as community property and one spouse dies leaving that property to someone other than the spouse, then those two people become tenants in common, and we'll talk about that. And there's a strong presumption of that should be separate community property, meaning if it is titled as community property, the presumption is as community property. You could conceivably prove otherwise, but the presumption by the court is that it will be community property. Again, creditors have rights. California's creditors' rights are different than other states. There is liability for debts of either spouse when it comes to community property, so pretty weak asset protection. So let's look at Oscar here. Well, Oscar, before he dies, conveys Greenacre to Abel and Baker, spouses, as community property. Abel dies without a will. Under California's laws of intestate succession, Baker inherits Abel's half of the property because Baker's the surviving spouse. So absent a will, if property is community property, and again, the presumption here is that it's community property because the deed says community property. Abel dies, Baker comes to us. Now, Abel could leave Abel's half of the property to whomever Abel wants, but Abel doesn't do a will. Baker comes to us. We initiate what is called a spousal property petition, and we file that in the county of Abel's residence, not where the property is located. And then we guide Baker through a process, typically is one court hearing, not a full-blown probate. And after that one court hearing, Baker then owns 100% of Greenacre in Baker's name, and now again, solely in Baker's name. So if you want to figure out what happens to if Baker owns the property solely when Baker dies, you would kind of rewind what we just watched. So community property with right of survivorship, what the heck is that? Well, it is similar to community property, except at death, the property passes to the survivor. It is not distributable by will. The right of survivorship can be unilaterally terminated by one spouse, meaning just one spouse says, I don't like this right of survivorship, so they can file something, whatever it is, with the court, or not with the court, with the recorder, terminating the right of survivorship. But it can only be used, this is important, it can only be used when 100% of the property is owned by the community. So you can't really do this with if you have multiple owners of the property other than the spouses. A little bit of a wrinkle on that. Creditors do have rights. Again, they're liable for the debts of either spouse, and the survivorship must be expressly stated. So what does that mean? Well, what that means is Oscar conveys Greenacre to Abel and Baker, spouses, as community property with right of survivorship. If you buy a property and you're married, the title company, I'm not kidding, will give you 9 options. There are 9 options on how to hold title to property. Pay attention to this, because you may not want your community property going to your surviving spouse. It may go to a trust for the benefit of your surviving spouse, right? It may go to somebody else, but you really do need to pay attention to this, because real estate in California can be very valuable, and people can be under a false assumption that their estate will be distributed in a certain way, and it's not. And frankly, this is why a living trust is the foundation, I think really a superior foundation to all other foundations, right? I mean, I will say an absolute here, for Californians. So if you own property in California, a living trust is really the best way to go. So Abel dies without a will. Abel could die with a will. Let's say Abel said, I want to leave everything to my kids and not Baker's kids. It's not that property's still going to go to Baker, right? But because of the title, Baker inherits the property at death. Because Baker is the surviving spouse. So it doesn't matter what Abel's estate plan says, right? If the property is titled in the name of Abel and Baker spouses as community property with right of survivorship, Baker is going to get it. So Baker hires Cunningham Legal to prepare an affidavit that is recorded with the county recorder where the property is located, not Abel's residence, but again, where the property is located. And then we guide Baker through the process. And after recording the affidavit, Baker then owns 100% of Greenacre in Baker's name and is the sole owner without having to go to probate. So you avoid probate with community property with right of survivorship. You do not avoid probate court with community property if there is no right of survivorship. Joint tenancy, we see this quite frequently. Spouses can hold property as joint tenancy. Basically, any number of human beings with heartbeats can be joint tenants. Now, why do I say human being with a heartbeat? Because if you die, you're not a joint tenant anymore, right? You have equal ownership. It's going to be halves, thirds, quarters, or fifths, meaning if you have 3 people, it must be thirds. It can't be, 25, 25, 50. That would be tenants in common, and we'll talk about that. They have to go on title at the same time. So when somebody says, oh, I want to add someone as a joint tenant, A and B want to add C as a joint tenant, A and B would create a deed that conveys the property from A and B to A and B and C as joint tenants. So if that's happened and you wonder, well, why are we conveying the property to ourselves? That's just the legal requirement in California and many other states. Joint tenants have an equal right of possession. So if you have a single family home with 3 people as joint tenants, they can occupy the entire property, the entire house, the entire home. A transfer of one joint tenancy interest severs the joint tenancy as to that person, and the new owner is a tenant in common with the other joint tenants. I'm trying to go through about 6 months of law school, by the way, in probably 20 minutes. I don't know if I'm going to do it. Just bear with me on that. At death, the interest ends. The survivors own the property. So let's assume people are on title. They all went on at one time. You have 3 people on title, and we have an example on this. One person dies. The other 2 get the property. That third person's estate does not get the property. The last human standing, the last human with a heartbeat, standing becomes the sole owner of the property. Creditors have rights, and one joint tenant's interest may be sold, again, severing the joint tenancy, and then the creditor would become potentially, or the buyer would become a tenant in common. And it must be expressly stated as joint tenants. California does not require joint tenants with right of survivorship. Other states do. Texas is one of them that requires, at least when I handled a case 20 years ago, required joint tenancy with right of survivorship in order to have the right of survivorship. But under California law, it does not have to say with right of survivorship, but it is helpful. Oscar conveys Blue Acre to Charlie, Delta, and Echo as joint tenants. Charlie's unmarried and dies with a will and living trust that leaves everything to Charlie's children. So Charlie owns a property with two other people, but says, you know what? I want everything I own to go to my children. Charlie dies. Delta and Echo inherit the property. Charlie's kids do not inherit the property. Sorry, Charlie. I don't know. This is a commercial from the 70s. Sorry, Charlie's kids. The full value of the joint tenancy property is included in Charlie's what we call gross estate. Now, this is a little bit of preview of federal estate tax. So if you own property as joint tenants with somebody else, the presumption is you are the one who put up all the money for that property. So Charlie's, unless it can be proven that Delta and Echo contributed to the purchase price, or to the extent they contributed to the purchase price of the property, and then if they, to the extent they've contributed to the purchase price, then it is not included in Charlie's estate. There is a 1/3 adjustment in cost basis on the property, and we'll explain what that is. But bear in mind, best case scenario, Charlie's third is included in Charlie's estate. Charlie's kids pay death taxes. Delta and Echo get the property without paying death tax. Just let that sink in. Tenancy in common, any number of persons. Now, this goes back a little bit to Mitt Romney's statement that, well, corporations are people too. I don't know if you remember that back in the day. These would include living and dead humans, AKA estates. So a living human is a person whose heart is beating. A dead human is a person whose heart has stopped beating. Pretty obvious. That is an estate, okay? That's a decedent's estate. LLCs, partnerships, and corporations can be tenants in common. They can be equal or unequal. You could have two people owning property, 90-10, 50-50, whatever. Separate legal title as to undivided interest, meaning this is an undivided interest. So it is not that, if you have a 50-acre parcel and two owners and it's 50-50, they each have the right to occupy the whole. So they each have the right to occupy at the same time the 50 acres, unless there's an agreement to the contrary, right? That would be a tenancy in common agreement. Each interest may be conveyed separately. This is a basic tenet of Anglo-American law, that property is freely transferable. Now, you may pay taxes on it when you transfer it. It doesn't mean you're not going to pay tax, but it's freely transferable and we don't have restrictions. So you can't say, I'm going to sell this property to you, but I only want you to sell it to people who are 5'5" and taller, okay? That is not a restriction that you cannot put that on a deed restriction. That's unenforceable. The purchaser of a partial interest in property becomes a tenant in common. At death, very important, at death, the property goes to At death, the property passes by will, and the heirs become the co-tenants, or the people who inherit the property, right? The devisees under the will become the co-tenants. So they step into the shoes of the person who's deceased. This is unlike joint tenancy, where that interest in the property just goes to the other joint tenants. Creditors can sue and take the property and become a co-tenant, or sell it, or force a sale. And there is a presumption of tenancy in common in doubtful cases. So when in doubt, the default is tenancy in common. So if there's a dispute as to whether it's joint tenancy or some other type of form of joint ownership, the default is going to be tenants in common. So Oscar conveys Red Acre to India, Juliet, Kilo, and Lima LLC as tenants in common. India dies with a simple will. Mike, who's India's son, is named executor and sole devisee under the will, or the heir, and hires Cunningham Legal to represent Mike in probate court to admit India's will to probate court. 16 months after hiring Cunningham Legal, the probate's concluded, and the 25% interest in Red Acre is ordered by the probate court to be distributed to Mike as executor, to Mike individually, and then we prepare a personal representative deed for Mike that he signs before a notary public and is recorded. That perfects the title so that Mike is now a co-tenant with Juliet, Kilo, and Lima LLC. That is an example of a tenancy in common. In the process, this answers the question, what do you do with real estate? What do you do with this? Well, you go through a probate process if you're a tenant in common. Let's look at title in an entity. So partnership, LLC or corporation, and there's a little bit of nuance here. This is where the entity is on title. So the ownership interest is defined in the partnership, the LLC, or the corporate agreement, or the corporate records, whatever the documents are. The ownership structure is not defined on the deed itself. So with tenancy in common, with joint tenants, with community property, your property interests are defined on the deed themselves, right? But when it comes to an entity, we have to look at other documents to determine who owns what. And this is property that's used for partnership purposes. And I use partnership loosely to include LLC and corporation. The purchaser acquires an interest in the partnership itself, not the property. So this is an example. If two people are partners and one partner sells to another person, that person does not acquire an interest in the property, they acquire an interest in the partnership, and that matters. At death, the interest passes pursuant to the partnership agreement. So it's whatever that partnership agreement says. That partnership agreement could mimic joint tenancy and say the surviving partners get it. It may not. It may be something, it just depends on what the corporate documents, the LLC or partnership say. The creditors can get a share of the profits, or in California, if it's a California LLC, those creditors can foreclose on the partnership interest or the LLC interest and become a partner. Other states like Wyoming, if it's a Wyoming close LLC, do not let that happen. So a lot of our clients will have their individual properties in an LLC and then have the shares of those LLC owned by a Wyoming LLC. And what that does is that gives you the protection of what we call a charging order for Wyoming LLC, but it protects you from having a creditor become a partner with you, or your partner's creditor become a partner with you. So they're staying out of that partnership structure. So if that's of interest to you, that's something we can certainly talk about. And what if there's no partnership agreement? That's a problem, because a partnership does not have to have an agreement. An LLC does not have to have an agreement. A corporation does. A corporation has to have bylaws in order to be a corporation. That's a tough one. So let's give an example here. We have let's look at an entity here. Oscar conveys Whiteacre to Whiteacre LLC, a California limited liability company. Papa, Quebec, and Romeo are the members of Whiteacre LLC. So we got Papa, Quebec, Romeo, three members, kind of partners. Papa, who's single, dies, owning his LLC interest in his own name. Papa's family initiates a formal probate action. Quebec and Romeo buy Papa's LLC interest from the estate of Papa in Whiteacre, and Quebec and Romeo continue as owners of Whiteacre. It's important. Most LLC agreements actually say this, or well-written agreements would say that, look, we want to be, Quebec and Romeo want to be partners with Papa. They don't want to be partners with Papa's kids or whomever succeeds to the property. They want to just buy that person out. So this is important. Title doesn't change. The question is, if title doesn't change, can they do this without probate? Because you say, if Papa's family shows up and they say, hey, here's Papa's will that leaves everything, and we don't have to go through the hassle of probate. The problem is that the manager assumes liability for this, because if that is not actually Papa's last will, or if it's a forgery, or if it's a fraud, and it is later proven that it's a forgery or a fraud and not the actual will, then Quebec and Romeo might have to pay the estate as well as Papa's family, right? It's Papa's kids. So bear with me on that. The nice thing about a probate order is that protects Quebec and Romeo when it comes to cashing out Papa's family. A living trust can be a tenant in common with other parties or not. Sometimes we see that. Sometimes two families will buy an investment property or a vacation home, and one trust will own half, the other trust will own half. Title's in the name of the trustee, not just the trust. So when and we have an example on this, what the title would look like. I think a lot of do-it-yourselfers or homemade jobs did DIY. A lot of times they'll just put the name of the trust. Well, you need a person to sign on behalf of the trust. So it's a good idea to put the name of the trustee, because that's the human with the heartbeat and a hand. Suppose not a hand. That's the human with the heartbeat who will be signing on behalf of, who will be signing off on the property. Rights of possession are specified in the trust document. Transfers must be authorized by the trust. So the transferee, the person, buying the property, can obtain bare legal or beneficial interest. So where I'm going with this, and at death, the beneficial owners are the beneficiaries named in the trust. If it's a living trust, it can be changed at any time. There is a functional problem with handling investment property in a living trust. And a lot of times banks don't like to lend if the trust is the borrower. Many times they make that property come out and go into the name of the human. And this is why a lot of our clients, if they have investment properties, right, that's why they put those properties into an LLC, because it's just easier, right? So the identity of the successor trustee are defined in the trust agreement. The creditor may obtain an order for execution by sale if they get such an order. But again, the trust is designed to provide for beneficiaries. It is not designed to pay a decedent's creditors. All right. So it doesn't mean that the living trust won't ultimately pay those debts, but there is not a forum that you must open. For example, in a probate, you have to open this forum where creditors can come in and make a claim. And not only that, in a probate, your executor has to make an affirmative communication with all the known or reasonably ascertainable creditors and say, hey, you got a year to file a creditor's claim. That kind of stinks. You don't have to do that with the trust. So that's the big difference between a will and a trust. And you can see why a living trust likely very superior to doing a probate. So Oscar conveys Red Acre to India, trustee of the India Trust, dated October 24th, 2024, the date we are doing this webinar. India dies, and the successor trustee of India's trust hires Cunningham Legal to prepare an affidavit that is recorded in the county where the real property is located, not where India passed away or lived. After a while, the successor trustee then distributes the 25% interest. Actually, would distribute the interest in Red Acre to the trustee of an inheritance protection trust for Mike, right, her son, so that Mike's inheritance is protected from Mike's creditors, and divorce. That's an inheritance protection trust. So a living trust can have inheritance protection for the person inheriting. Debt on real estate and acceleration clauses. If you have debt on real estate, if there's a note on the property, is it accelerated on death? What am I talking about? For California, debt on real property, California uses a non-judicial foreclosure. A mortgage, so we hear the term mortgage, it's really a note that is secured by a deed of trust. What am I talking about? Well, when you go to borrow money, you're going to sign a note. I promise to pay the bank such and such money on such and such terms. You're also signing something else. It's called the deed of trust. This is very confusing because there's also a term called a trust deed. That is the deed where you transfer title of the property to the trust. A deed of trust, and again, super confusing, terrible language used here. A deed of trust is what is called a security instrument. So what that means is if I borrow money from a bank, I promise to pay based on the note. But what if I don't make my payment, right? How is the bank going to get its money? Well, they're going to foreclose on the property, but they don't want to have to go to court to foreclose on the property. That would be a judicial foreclosure. So what I've done as a precondition to me getting a loan, I have had to sign a document that says, in the event of a default, I am appointing a third party to sell the property, get cash, and pay off the note holder. So that is the way most debt is structured on real estate in the state of California. And that then generates the money to pay off the note. The question is, what is a default? Well, obviously, a default is not paying the payment. I mean, that's kind of obvious. But is death a default? You need to look at the note, because sometimes a note is accelerated on death. Sometimes it's not. Now, your attorney can look at the note, probably should look at the note, and other documents to determine what steps, if any, need to be taken, and the deadlines. So this goes back to the question is, do you need to do anything when somebody passes away? Well, if there's an acceleration of the note, you're going to need to deal with that reality that you're going to have to pay this off. And because the bank doesn't lend on property, the bank lends to the borrower, right? That's why they pull the borrower's creditor, the credit rating. So if mom and dad have a credit of 800 and the kid has credit of 600, the bank probably doesn't want to lend money on the same terms. Let me just put it that way. So very, very important to pay attention to those details. Here's a little bonus tip for you for those who got a U.S. Economic Injury Disaster loan, an EIDL loan. The EIDL loans, especially those over $250,000, typically have an acceleration clause. Now, these are unsecured. That means that when the borrower dies, the remaining balance of the loan is due. So that $2 million loan that you might have gotten at 3.75% over 30 years, guess what? If you die, that probably becomes due. And that is going to be a problem for your surviving spouse and your family, because you need to pay attention to that. And we have had this happen in two cases recently in this year in our firm, where people died with an EIDL loan, and that SBA, they are coming after their money. So there's not a whole lot of wiggle room on that one. You got to pay. You got to pay that note. Mandatory reporting to assessor at death, change in ownership, and reassessment. The dreaded reassessment. Those Prop 13 taxes that you love, thanks to Prop 19, largely gone. Death is a change in ownership. Let me repeat that. Death is a change in ownership. A lot of people don't realize this. They say, well, isn't it when I get the property from the probate? Or isn't it when the property is distributed after somebody passes away? No. Death, the moment of death, that property changes hands, is subject to reassessment. And here's the problem. A lot of people don't know this. So a lot of people don't do anything. They say, well, I went to my CPA and the CPA said, oh, just file an affidavit of death. Don't worry about it. We hear this a lot. Financial advisor said, just file the affidavit of death. Or an attorney maybe who just doesn't want to deal with it. They go, you'll get title, affidavit of death, move on. You need to notify the assessor of the change in ownership, because that property is reassessed as of the date of death. And if you don't get on it, then there are penalties associated with that. So, it's my job as a lawyer to tell you what the law is and tell you to follow the law. But understand that there's a change in ownership. Now, here's a problem. If it's a house that maybe is assessed at $100,000, but it's worth $2 million, which is not uncommon in California. Mom and dad bought that thing 50 years ago. Those taxes are going to go from maybe, $3,000 to $25,000. If you hold that property for a year when you're kind of figuring out what to do, and then you finally list the property, maybe you're fixing it up, cleaning it up, there's typically a lag time. And then you sell the property, distribute all the assets to your siblings from the trust. The assessor typically sends out this supplemental unsecured tax bill 11 months after they find out that there's been a change in ownership. So if mom and dad die and a year goes by and you sell it and you distribute all the money to your siblings, 11 months later, you're going to get a tax bill. It is unsecured, meaning you personally owe that money, right? Unless you have a refunding agreement with your siblings, you can't get money back from them. If they say, no, I'm not going to give you the money, there's no legal mechanism to get the money back, and you owe the tax. So it's very important to pay attention to this. The personal representative, whoever's acting on behalf of the decedent, is responsible to notify the local county assessor. There are exceptions. Transfers between spouses and registered domestic partners are categorically not changes in ownership. And we have a limited parent-to-child reassessment exclusion now under Prop 19. There is a potentially expansive co-tenancy exclusion that we cover in other webinars. So if two people are on title and it's both their residents, and one dies and that other one inherits the property, there's no reassessment. Now that's a big deal, right? Now you have to go through some hoops on that, and we do cover that in other webinars. And there is a very limited joint tenancy reassessment exclusion, but this is typically not suitable for the purposes of wealth transfer or asset protection. So I would say if you're looking at this and you go, ooh, maybe there's some unknown joint tenancy exclusion, you're just going down a rabbit hole, and that really is not helpful in the vast majority of cases. Very, very narrow set of facts where that works. And again, deadlines exist to claim your reassessment exclusions. So pay attention to this. Don't just stick your head in the sand for 3 years. You're going to blow through all the limitations, the time limitations, and be subject to penalties as well as additional taxes. What is a change in ownership? What am I talking about? I said death. Obviously, a sale is a change in ownership. Gift is a change in ownership. Not all gifts are a change in ownership, though. And if you make a gift of property with a retained limited power of appointment, which we don't see that often, that is not considered a change in ownership. So it's one way to get a property to your children for them to use. There are a lot of different ways to do that. And again, we cover that in other webinars. Transfer of present interest. What is a change in ownership? A transfer of a present interest in property, including the beneficial use thereof, which is essentially entitlement to rents or to occupy the property, the value the value of the transfer is substantially equal to the property itself. So there are a couple of cases there for you lawyers, Pacific Southwest and the Steinhardt case. But a change in ownership, again, what I really want you to focus on is death as a change in ownership. So you can sell it, you can lease it for 20 years with 3 5-year extensions. So if your lease is that period of time, then it's subject to reassessment as well as death. So Prop 13 covers what is Prop 13? What are we talking about here? People want to preserve Prop 13. We're talking about property taxes that are limited to 1% of assessed value, going back to 1975 values if you bought the property in 1978 or earlier. And those get fully reassessed when there's a change in ownership. Just give an example. This is actually me when I was a kid. I was maybe 6 or something. So I guess 8, 9. That's my dad's 1977 Lincoln Continental Mark V. They bought a condo in the 1970s for $24,000. They still have the condo. It's worth $600. Property taxes are $650 a year. So it used to be that I would be able to inherit that property and not pay higher taxes. That's gone, right? So now it gets reassessed, and there's the car. It's not the car, but for you car aficionados, that was it was too big to fit in the garage. What happens when the property taxes when mom and dad die? So my parents pass away. I've grown up. They're gone. Well, they kind of go up to the pearly gates, and that is a change in ownership. When they're both gone, the property's reassessed at its fair market value of $600. So the property taxes go from $650 to $6,000 a year because of the change in ownership. That happens at death. Why is this important? Because it may drive the decision. Do I keep this property? Do I sell it? Now, bear in mind, you are getting more basis on the property. So if I were to inherit this property, I would have basis, and I could start depreciating that based on a $600,000 valuation. The tax benefit may offset the higher taxes. It might not. It's purely a math calculation, and that's done with the CPA and financial advisor. So how do they know? Who's the they here? The assessor. How do they know that someone's passed away? You know, this is part of like, well, how does the government know if I give my kid $500,000? Well, you have to report that in a Form 709. Yeah, but what if I don't tell them? You know, this is a common question. What if I don't tell them? Well, you have to. So with real estate, they're going to find out one day, okay? And I'm a lawyer. I have to tell you to follow the law, okay? Within 150 days of the date of death of the owner of real property, the decedent's representative, whoever that is, if it's a successor trustee, the informal representative, the executor, must file a change in ownership and a copy of the death certificate with the assessor in the county where the property is located. So if you have properties in different counties, you got to file multiple forms. If the estate is probated, it's when the inventory and appraisal is filed, and that's basically the document that says what's in the estate and the values. Otherwise, an escape assessment and tax bill for each affected tax year from the date of death to the current tax year can be imposed, and liability falls on the decedent's representative. Understand this is a personal liability. They're going to come after the personal representative. So it's very important if you do assume the role of personal representative, it comes with significant personal liability that you really cannot discharge by statute. You're going to be 100% on the hook for this. And so it's very important to pay attention to, to following the rules, because you don't want to get stuck doing a bunch of stuff, not doing what you're supposed to do, distributing all the money to your siblings, and then you're stuck holding the bag on paying more taxes. So again, this goes to what should you do when somebody owns real property and they pass away. So India owns Red Acre and India's Living Trust, and titles held as India, trustee of the India Trust dated October 24, 2024. India dies and Mike does nothing for 10 years. There are no trust police. No one's going to come to the door and knock on the door. If he does nothing and keeps paying the tax bill, the assessor is not, at least that I'm aware of, not combing the Social Security death index to start matching names. After 10 years, Mike begins a process of selling Red Acre. Mike finds out that Mike is 10 years delinquent on notifying the assessor, and he's hit with significant back taxes and penalties. So very, very important to pay attention to that. New federal reporting requirements for LLCs, partnerships, and business corporations, and what we call a business trust, which is kind of a legacy, has nothing to do with a living trust. It's a legacy structure that it largely was replaced by LLCs, and is used by REITs, real estate investment trusts. So this was a bipartisan bill that was enacted requiring many small businesses, so these are typically businesses with fewer than 20 employees or less than 5 million in revenue, to report their beneficial owners to the Financial Crimes Enforcement Network, or FinCEN. This was part of a National Defense Authorization Act. The translation, the reason I say what act this is from, This is serious business. The government is trying to impede terrorism, the funding of terrorism, and organized crime. So this is a big deal in the legal world. That this expands the anti-money laundering laws, and it's intended to combat, again, money laundering, terrorist activities, tax fraud, and other illicit activities. If the business ownership changes, and this includes death, you have to update this information within 30 days. So if mom and dad die and they own an LLC that owns a building, you have 30 days to report this information. So you may not even have had the memorial service, and you have to report this. Now, you go on their portal, you go on their website and report it. This is serious business. So, and there's some deadlines here for entities that were formed in 2024, but 2025 is just around the corner. So this 30-day deadline is going to affect a lot of people. Death, capital gain, and tax avoidance, understanding the basics of basis. The basics of basis. We have a whole webinar on this, how to avoid and defer capital gains tax. Check it out. I'm going to give you a snippet of what we covered in this webinar. So capital gains, your gain, what is your gain? Your gain is the purchase price minus depreciation plus appreciation. Now you might say, well, Jim, I did a 1031. Well, what I'm talking about is sort of the original purchase price of the original thing you bought. Purchase price minus depreciation plus appreciation. So if you buy something for $1 and sell it for $3, and that's subject to capital gains tax. The current capital gains tax rates, if you have no income and you're a joint filer, you're not paying any tax on a fair amount of income, and it's graduated. It goes 15, it goes 20, then 20%. Recapture depreciation is at 25. California has no capital gains taxes. They treat the 10 brackets. The 10 brackets are too many to list. I would assume 10 to 13.3% when you're kind of spitballing what your tax bill is going to be. So Delta buys Greenacre in 1994 for $375,000. The property's fully depreciated after, 1994 to 2004. The cost basis is now 100, which is the value of the land. Delta sells Greenacre for $1.375 million, and the $1 million gain is taxed at a maximum 37.1% because Delta has other income. The tax is $486,000 and change. That is 35% of the sales proceeds. But when you factor in inflation, which as of late has been a very hot topic, when you look at inflation-adjusted dollars, the tax bill is 83%. Why am I making this sort of really depressing slide? My point is, this is higher than income tax after factoring in inflation. So, I mean, the income tax rates are graduated for inflation, but your basis is not adjusted. There's no inflation adjustment for your basis, which, kind of makes sense, broadly speaking, but is just not part of the tax code. So what is the moral of the story? It's better if Delta waits until she dies until the property is sold. Because if the property is included in Delta's gross estate, it receives a full adjusted cost basis. So let me give you the same facts. Delta buys Greenacre in 94 for $375. It's worth $1.375. The day Delta dies, Echo, Delta's child, can sell Greenacre right after Delta dies for $1.357 million and pay no capital gains tax. Now, this assumes that this property is included in Delta's estate. Or Echo can hold on to the now reassessed property, because it's rental property, right? And continue to rent the property to tenants. Delta's going to pick up depreciation over 27 and a half years. So the property will have, the dirt will be valued and the bricks and sticks will be valued. The bricks and sticks are depreciated over 27 and a half years, meaning the government presumes or pretends that building falls down after 27 and a half years and you've had this loss, and it does so 1 divided by 27.5 every year. And this may be enough to offset the higher property tax. So this is where I'm going with this. This is a tremendous tax benefit. This is a real tangible tax benefit. So the moral to the story is, if Delta wants to get the property to Echo, it might be better to do that when Delta dies, because Echo is going to have a low cost basis. This goes to basis management. And this is one of the principal challenges when, we have the sunsetting of the tax exemptions that we're going to talk about here. This is one of the principal planning constraints, puzzles, whatever you want to call it. Rubik's Cube in planning is we want to make sure that we preserve to as much as we can that adjusted cost basis. That has to be balanced with death taxes. So let's talk about federal estate and state death taxes, I lump these together as death taxes, plural. And the reason I do, this is not a political statement, is because there are state and federal taxes, hence the term death taxes, plural. Here's the key takeaway. We had the Tax Cuts and Jobs Act in 2017 under the first Trump administration. When a person dies with a taxable estate, a Form 709 is required to be filed within 9 months of death. The current exemption is $13.61 million for 2025. I don't know why they didn't use round numbers. Why couldn't they just use 13.6? In 2025, it's going to 13.99. Seriously, people, like, can't you just call it 14 million? It just makes the math ridiculously hard. Each state is free to impose its own death tax on decedents who are residents of that state, right? Or own tangible property in that state. Real estate is tangible property, meaning you can walk up and touch it. Stock certificate, I mean, you could touch a stock certificate, but that is considered an intangible, right? So the federal tax cut, death taxes are a frosted cake. What do I mean by that? In 2011, we got an Obama cake of 5 million plus inflation. That's the cake. The Trump frosting is 2017. Put those together, it's 13.61 million. When you make a gift, you got to make it from the cake first, then the Trump frosting. So you got to make it from the Obama cake first, then the Trump frosting. You're not slicing it vertically. So if you say, gee, I'd really like to make a gift of 6.8 million and use up this Trump exemption that looks like it's going away at the end of next year, you've got to give your Obama exemption, which is 6.8 million, and then you've got to give the Trump exemption. So this presents a real planning issue for attorneys. But again, in 2026, January 1, 2026, that frosting is going to be wiped off. We'll be left under current law with an exemption of about 7.2 million adjusted for inflation. So that is set to go. The amount you can leave tax-free is set to go down to 7.2 million, and the tax rate is set to go up to 45%. So I would say consider assembling your A-team like now if you're concerned about this. This is the attorney, financial advisor, and CPA, not the A-team from the 80s, but it's the attorney and CPA and financial advisor. Get those people together. Next up, we have Pet Trust, Your Pet's Care Covered. That is our November 7 webinar, all things pets. And I have a little dog, Lola, little rescue dog, Lola. She's way cuter than these two dogs, this dog and cat. But we're going to talk about pet trusts and how to care for pets. And if you're watching this on YouTube, please subscribe to our YouTube channel. That brings us to the end. We're going to open it up for questions. If you have any questions, please put those in the Q&A if you're watching this, if you made it to the end of this video, and you just keep watching because another video magically is going to roll up after this one. Thanks for joining us.